Pleasure to turn the program over to Erin to kick off our discussion. Thank you, Erin.
Thank you. Happy to be here. I can attest to the fact that journalists reach out to Jerry, by the way. I definitely have to help me translate many of these issues. So I'm part of the team that analyzes a lot of the legal things that happen in the labor and employment realm. So I wanted to go through some of the decisions from 2019 in the Supreme Court that we're already seeing have influence in lower courts, talk about some of the decisions that we expect to come in 2020 that will absolutely have influence on the lower courts as well. And then it was hard to choose, but I picked a few cases and trends that I think would be of interest to talk about. Okay, so I'm going to linger a bit on this because I feel like arbitration, so much of what I do ends up back at arbitration. And these two cases, Lambs Plus and New Prime, really add to a decade's worth of Supreme Court decisions that are influencing arbitration moving forward. New Prime essentially said that independent contractors should fall under this carve-out where they won't fall under the FAA's arbitration, that bolsters arbitration. I have seen New Prime cited frequently by plaintiffs' firms, and in many of the cases, this one's probably the one I've seen the most in other courts so far. It's really it will influence things moving forward. And I wanted to point to, in the Third Circuit even ruled that passengers as well as food delivery drivers who transport food, they can fall under the exception for interstate commerce as well. And that was a really interesting argument, and it's one to watch because arbitration has insulated many companies from class action battles, as we know. So, and that'll be even more potent in states that adopt the ABC test, which I want to talk about a little later. And Lambs Plus, another arbitration case, created a barrier for class action arbitrations, and so this will hopefully be helpful in contract formation, and it kind of removed some of the ambiguity in these cases. So I'll move on to the next one. Home Depot case, it was an administrative one where it was about third-party counterclaims, and it was a question of expanding a 1941 case, Shamrock Oil. And I read the U.S. Chamber's opposition brief, and because they kind of helped explain it, and they basically said that a third party should not have say in the original choice of forum, and not be locked into a state forum of their opponent's choosing. And the court ultimately agreed, and so that'll be influential moving forward and provide clarity in that area. Parker Drilling, I shared this with Jerry before we began. I was the only reporter at the Supreme Court hearing, so I hope that does not mean that it is not of interest to anyone, but this was an interesting one. It's about offshore rig drillers, and the Ninth Circuit decided that the kind of more worker-friendly rules should apply that are in California should apply to the rigs that float off the coast there. And the Supreme Court overturned that decision, but if they had gone the other way and upheld the Ninth Circuit's decision, there was some concern that would apply to the offshore rigs that in the Gulf, which is a lot more, and then state laws would apply to them. And I included Kaiser versus Wilkie on here because it dealt with the hour deference, which determines whether courts should lean on agency interpretation of regulations. Possibly business groups would have liked the standard to be eliminated altogether, but this one's relevant to us in the labor team because the DOL, OSHA, and the EEOC all issue interpretation of regulations, which have been used in litigation. And this ruling certainly weakened the hour deference. So that's something that both the departments and lawyers should probably pay attention to. Okay, so these are the ones that we're watching this year. The first, I don't have this listed on here, but Of course, the biggest case that we're watching in employment law is whether sexual orientation and gender identity should be protected under Title VII of the Civil Rights Act. That highly anticipated ruling will be interesting to watch play out. I attended that hearing as well. And I just wanted to point out, I think something that'll be interesting for the workplace is a lot of the justices asked questions about bathroom and dress code policies, specifically with the transgender question. And I think that'll be something that'll affect the workplaces however this decision comes down. And of course, I'm not going to make any predictions, but we're waiting for that decision in the LGBT Title VII cases. And the next two cases are about but-for causation. And the first is Babb versus Wilkie. And I think that Justice Kavanaugh called this the OK Boomer case, if anybody follows oral arguments very closely. But this will solve an appeals court split on the causation standard for age discrimination complaints under the Age Discrimination in Employment Act for federal workers. And so it'll obviously either make it easier or harder to prove if there is age bias, be it but for or motivating factors. There was an interesting back and forth on this issue. The court asked the DOJ, which is representing the government because it's a federal government case, and the workers' attorneys to provide supplemental briefs. And the DOJ had a pretty remarkable materials arguing that federal employees already have other ways to file age bias claims outside of the ADEA. And so that's a pretty remarkable document if anybody likes to dig into Supreme Court dockets like I do. And the next case actually revolves around a Reconstruction era law that is often filed around Title VII claims alongside Title VII claims, and they're analyzed similarly. It's not an employment case, but I think this could affect workplace decisions moving forward. Comcast wants but-for causation as opposed to motivating factors to be used to analyze a race discrimination claim brought by an African-American owned media company. And so those will be very interesting. And we see a lot of but-for causation cases and those questions in lower courts as well. So these are both poised to provide some clarity there. And the next one is, it's actually a pair of cases. I listed Our Lady of Guadalupe School, but they involve two different cases where Catholic school teachers attempted to file disability and race claims, respectively, and the schools argued that they should fall under the ministerial exception for claims, which means they're not allowed to file these suits. And so it'll be really interesting to see how the Supreme Court comes down on this, and whether, because it could potentially expand what is considered a religious job duty. And I just find any kind of clash between religion and discrimination extremely interesting. So I think this case has not been heard yet. It will be heard on April 1st, I believe. So that brings us to some of the topics that I chose as employment trends. And I feel like the question so far this year seems like a very basic one. Who is an employee? But it seems to be very complicated in a lot of the litigation that we see. A lot of the litigation we've seen at the beginning of this year, we're focusing on the ABC test in California, and in other states that use this higher standard for determining who is an employee or an independent contractor. And a lot of the business community has been stressed out about this and kind of deciding what to do if they're gonna, because and even franchisees or joint employer relationships, they're kind of wondering how they fit into this new stricter classification. And meanwhile, progressive states are following suit. The ABC test has already been met with challenges. Gig economy companies, Uber and Postmates, are trying to challenge it, and they're also pushing for a ballot petition to try to overturn the law. There are freelance journalists who sued against the law, and successfully the trucking industry filed a They actually successfully got a preliminary injunction against the law for now, are having a unique argument. And these laws are really focused on, I think a lot of people see them as anti-gig economy laws, but I think they're really affecting janitorial companies, they're affecting construction workers, I wrote a story about strippers who are going to be affected by this. I'm not joking. And it'll really be a test for a workplace that some people call a fissured workplace, where a lot of employers subcontract out a lot of their work, and there'll be kind of a reckoning for that. And so that's why I mentioned the joint employer issue, because 3 agencies are looking at this right now. The Labor Department, the NLRB, and the EEOC are studying how to address joint employer issues. And so I think that's definitely going to be a major theme moving forward and something to pay attention to. This also dovetails with my next topic, which is arbitration again. And actually, just this week, we covered a story where more than 5,000 DoorDash couriers will all be entering at once. They were compelled into arbitration with. At one, they'll have 5,000 individual arbitrations at once with DoorDash. The judge actually ruled against DoorDash in this, forcing them into arbitration as opposed to halting it. This was the latest example of a court forcing this issue for arbitration that a company asked for, and plaintiffs' attorneys do, I think, have a hard time getting all of these demands at once, but they still, when they do it, there is a lot of pressure on the company to pay that at once. I believe the bill for the filing fee for DoorDash was going to be about $10 million just to start the process, and that doesn't include, of course, for each individual arbitration, it could be up to about $10,000 each. And so I think this is a pretty good way to either force a settlement or not. And we've seen it. Uber reached a huge settlement last year in this. And so I think that kind of tactic is something that will move forward as a lot of these companies use arbitration agreements or prefer arbitration, but then are faced with somewhat of a class action on their hands, but maybe in a more difficult process. And so I just thought I should mention 2 cases that I have listed here that were both issues of first impression, both in the Fifth Circuit and the Seventh Circuit. And they raised the question of when notice should be given to the workers in a collective action if they have either signed arbitration agreements or the company claims that they should be taken from the group because they have. And they were slightly different cases, but they were both issues of first impressions in these appeals courts. And I will be curious to see if more come forward in these. So I just wanted to talk about 3 more topics. I've been very interested to cover, and there was this issue almost made it to the Supreme Court last year about the salary history bans. A lot of workers' rights advocates and the EEOC say that employers' practice of asking salary history to hires can further perpetuate the cycle where women and people of color make less money than their white male peers. And so Philadelphia made its way up to the Third Circuit, and its law that bans employers from asking job applicants about their salary history will move forward for now. And this could potentially, people I talked to for this story said that could, bolster similar measures around the country that are aimed at targeting these pay gaps in the workforce. And that was so that'll be a really interesting topic to watch, because that could have been a difficult case for them to win. And there are so many states and cities that are adopting those laws. And so if there's a challenge, they might be able to point to that Third Circuit decision. Similarly, we see a lot of pregnancy discrimination cases and how to deal with that. I would point to a case in the 11th Circuit. There were recently oral arguments at a federal appeals court in Alabama. And the question is whether an employer can categorically deny pregnant employees accommodations. And it provides a test to a Supreme Court case, Young versus UPS. And I just think it's one to watch because it'll test an important issue. And we really do see a lot of these cases in the lower courts. So we don't know if it'll maybe make its way up higher. But, and then the final one is, again, it seems a little wonky, but these three cases that I have listed here, I'll mention one about, there's going to be a decision on it. Whole Foods is attempting to impose a strict jurisdictional rule to stop class members with no connection to the place where the lawsuit was filed from pursuing the claims for unpaid wages. So depending on how these decisions come down, it could essentially add restrictions on nationwide class action. So I think it'll have there are three cases, so I feel like the issue is ripe for exploring and paying attention to. So.
Great.